Good evening and welcome to this month's webinar, Alimony Reform, What Are My Rights? Give a little background about what to expect from today's webinar. As I said, it's going to cover the new alimony reform. The webinar, all of our webinars are intended to be 45 minutes in length. Sometimes I go a little longer, sometimes it's a little shorter. Never really know until I get through all the information, but I do try to keep it inside of that time frame. You'll notice it's a one-way communication, so you can hear me, but I can't hear you. There should be a pane on the right side of your screen that allows you to type in questions, which I urge you to do throughout the webinar. Don't wait until the end, so that in case there was something you wanted to ask, but you don't remember it at the end, it's good just to put it up there. I believe that nobody else but me can see the questions that you post, so you don't have to worry about anybody knowing what you're asking or any kind of confidentiality issues. I am recording the webinar. I will make it available after today for you to review again on your own time in case there's something you want to hear again, or if you're not able to sit through the entire seminar. You should also receive, after the webinar, I think it's maybe even tomorrow, a brief survey about the content and the webinar that we are holding today. I would appreciate it if you could take some time to answer the questions on that survey. It helps me a great deal to get feedback from people so I can find out what is working, what is not working for people, so that future webinars can be better tailored to your needs. Okay, so for those who have not met me before, this is me. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I've been a practicing attorney for about 18, 19 years now. I'm a member of the New Jersey and Pennsylvania State Bar. I'm also licensed to appear in both state and federal courts, which includes the 3rd Federal District. I started my law career working as a judicial law clerk for the Honorable Eugene Austin, was a special civil judge in Bergen County. It was a one-year position. It was a great experience in that I got to learn what happens in the courthouse sort of behind closed doors. What happens when you file papers? What do judges do with it? What do they like and dislike that lawyers do and don't do? So that 1 year was a tremendous experience. I then moved on to doing complex commercial litigation with Kessler and Associates in Clifton for a number of years. That too was good experience in that the litigation that we do at the Micklin Law Group is complex and civil based, even though it's family and divorce law and estate planning, but it's still civil litigation as opposed to criminal litigation. My practice is concentrated in complex divorce, family law cases, and estate planning. Now, the Micklin Law Group itself is also concentrated in those areas, but we do a much broader practice of divorce, family law, and estate planning and litigation. We have 2 associates in addition to myself. One is Rachel Isaacs. She is our senior litigation associate, and Richard Muglia, who recently joined our office as our newest associate. We have various support staff that you may or may not have met or will if you need our help in the future. Carmen Figueroa, who is our client service manager. We have Stephanie Morosco, who is our paralegal, and I often have various administrative staff that you may deal with from time to time also that assist us in handling our matters for our clients. All right, so let's first take a look at what the current law is. I think it's important to go through the current status of the law for many reasons. First, I don't think you can fully appreciate the changes or the proposed changes unless you know and understand what the current status is. That way you know what the difference is. But also, more importantly, my personal opinion on the reform is that it's not really needed. Neither of the ones that we'll cover, I think, are actually needed at all. The problem, in my opinion, is not that the law needs to be changed. The problem is that nobody follows the law. Anybody who's been involved in divorce litigation for almost as far back as I can remember, and we'll be able to tell you certain things about the way the process works. One, the majority of cases settle. So the majority of issues that are required to be considered by the statute for alimony are not in fact considered. What is considered is how quickly can we get this settled, and what are you willing to do. So most of the time people settle their case without really even contemplating the statutory factors for alimony. Then there's a lot of things that come into practice. You'll often hear things about like the 1/3 rule, where we take the difference between your income and we take 1/3 of it, or for length of alimony, we take 1/3 or one up to 1/2 of the length of your marriage. And again, none of that, and most of what you'll hear in court has nothing to do with what the statutory requirements are. Rarely will you actually have an attorney or even a judge that will go through these criteria for you, as opposed to just making it simple. And you'll also commonly find that, while we have here 13 different statutory factors, in practice, there may be 4 that are actually considered. Those are typically the length of your marriage, the ability to pay, the needs or the earning ability of the lower earning spouse, and the lifestyle. So, those are, and it's helpful to use those 4 criteria, but as you'll see here, there are many, many more that need to be and should be considered. And if it was our practice to consider it, we wouldn't need to reform. But enough of my soapbox. Let's jump into taking a look at the statutory factors. All right. Now, I'm not going to read each one word for word. I'll give you a moment or two as I'm going through it to sort of read through it and jot down the needs. But let's give you a little information about some of them so you can better understand what they represent. The first one is the need and ability to pay. And when you're in litigation, this is an important factor because you need to consider not just the current ability, but what's going to happen in the future, both for yourself and the other party, whether or not you're paying or receiving. You want to factor things like changes in occupation, cost of living adjustments, gifts from family members if it was a practice, or inheritances. Anything that's likely to change significantly in your future should be contemplated here. The duration of marriage or civil union. Now, this can be broken down generally into short-term, intermediate term, long-term, and permanent. Permanent. I'm not going to go into what I think each period breaks down to, but those are generally the main criteria. And your term of alimony will often correspond to the term of your marriage, not necessarily equally, but if you have a short-term marriage, you're likely to have a short-term alimony obligation. If you have a long-term marriage, you're likely to have a long-term alimony obligation, and in some cases permanent, depending on what happens with the reform, which we'll talk about in a few minutes. 3, the age and health of the parties. It's pretty self-explanatory. 4, the standard of living. Now, this contemplates a reasonably comparable standard of living, which really isn't possible, or in most cases isn't possible, because you're taking what was one household with 1 or 2 incomes, you're making it 2 houses with the same 1 or 2 incomes. So you're never going to have a reasonably comparable standard of living, but it's what the statute says. It's what we reach for, but in reality, it's just not necessarily there. 5, the earning capacities, vocational skills, employability. Again, just like number 1, you want to consider not just the current standards, but your future changes, whether it's good or bad. If somebody's going to go to school or likely to advance in their career, you want to contemplate that when you're looking at the alimony factors. 6 and 7 are sort of related. Length of absence from the job market, and the parental responsibility for the children. Parental responsibility for the children is what most commonly leads to a long absence from the job market, but doesn't necessarily need to be. There are some families where it's a 1-income household and one spouse hasn't been in the workforce for a period of time, so something you need to consider. Let's see, 8, 9, and 10. The time and expense to acquire sufficient education. Again, this is generally for the lower earning spouse to determine what their future needs are going to be. 9 is financial and non-financial contributions. Non-financials generally either raising a family, sometimes working while the other person is going to school and obtaining a degree or advanced training. 10, equitable distribution of property. This is Not always the most common, but it is something that needs to be considered. You need to look at what people are receiving now and in the future as far as interest income on investments, trust property, if a family may have has money in trust and they're receiving property and income from there. Number 11 sort of related to 10, the income available through investments. Again, a lot of people will receive income from various sources, family members, trust planning, even 401ks and retirement that may be either accessible or coming into pay status. 12, tax treatment and consequence for alimony. You may or may not know alimony is taxable, so the person paying alimony pays a little bit less in income tax. The person receiving alimony pays income tax. Judges are authorized to consider that when setting the actual number because each of the parties are likely to be in different income tax brackets. So sometimes it's better to shift the tax burden because there's more money available to both sides. And then 13, which I usually call the kiss of death, which is the best and worst thing about most statutes in family law, and that is any other factor that the court deems relevant, which really means that they're almost unfettered in their discretion. If they can find a justifiable reason to use a factor, it can be employed. All right, let's take a quick look at what the current types of alimony that exist, what they are, how they differ. Okay, so first you have permanent alimony. That is generally long-term relationship or marriage, a dependent spouse, things that cause or lead to long-term or permanent alimony, usually long absence from a job market, decades, 10, 20 years, where the person is just never going to be able to enter the market at a reasonable level and earn and live at a comparable lifestyle. There is limited duration alimony, and that is currently when a court finds that permanent is not appropriate. There it has to be economic need, and it's intended to give a period of time to allow the lower earning spouse to become self-supporting. We'll see rehabilitative in a minute, how that differs, but well, let's look at it real quickly because they're very similar. There's rehabilitative alimony to help the lower earning spouse sort of get back on their feet, get education and training. Now, the main difference is one, or is not one, but how they get modified or whether they can be modified. Rehabilitative alimony can be modified if at the end of the term set, the person's not gotten back on their feet. Where limited duration, which is more commonly granted, cannot be modified beyond the term that's set or agreed upon. Very significant when you're considering which type of alimony, if any, to enter or to agree upon. Reimbursement alimony, probably the least common of any form of alimony. It's compensation for support for the other person's education, meaning if one spouse worked while their other spouse went to med school, and then when the person graduates med school, files for a divorce, well, now that person is going to likely earn a very substantial income following that. But the lower earning spouse at the time really hasn't benefited from that education. The lifestyle hasn't increased. There might not be a long-term marriage. So the statutory factors for alimony don't really exist in the sense to award a person alimony, but that person has sacrificed a great deal and put the other spouse in a much better position. I also think there's a little underlying intent of fairness here, because there could be situations where a spouse stays married to get the benefits of support through an educational program like med school and then leaves once they got the degree. And I think there's a need to balance that equity there. And then there's penente lite support, which is temporary support that's entered during a divorce case. The court's supposed to use similar factors when issuing a temporary support order, but they don't usually. They look more towards maintaining the status quo, which means keeping the lower earning spouse's financial situation as close to the way it was when they were married and an intact family. So it usually mean paying all the house expenses. That would usually mean paying all the bills, but not actually having a support payment or a child support payment entered. It's more just an obligation to pay bills. And it varies. Every case is going to be different, but not most, but many cases will have a pendente lite order. It can often be a very tremendous burden to the person paying. It's also, in many cases, very bad for settlement because it sort of offsets the balance of power, but a little more in depth than we need to get to in this webinar. But just something to know that as you're going through a divorce, that you may be entitled to seek pendente lite support so that you don't need to pay all your bills and support yourself through the case. Let's look at the current standards for modification of support awards. And something to keep in mind, what I'm covering right now is generally for court-ordered or judge-ordered alimony awards. I'll touch in a minute how that may be different when you've actually agreed upon an award of alimony. So the standard for modification currently exists in the case Lepitz versus Lepitz, which discusses a substantial and permanent change in circumstances. And that's a very important conjunction because you may have a substantial change in circumstances, but the question of whether or not it's permanent is very convoluted and very challenging for most people under the current standard. The factors courts are supposed to look at: the spouse's needs, and that is the supported spouse, the lower earning spouse's needs, that spouse's ability to meet his or her own needs, the paying spouse's ability to pay despite this change in circumstances, and the marital standard of living, which was ruled upon in a case Cruz versus Cruz. If you're interested in the site to any of these, just email me afterwards. And that's why you'll find when you go through a divorce, you have to file what's called a case information statement, even if you're settling your case and you don't want to have to go through the hassle or disclose it. But it's important because if you're looking at a modification many years down the line, the court needs to know what existed at the time where the parties agreed to do this in the first place. So some examples of changed circumstances: obviously increase or decrease in income. Now it's got to be a substantial increase or decrease. You can't likely say if you were making 100,000 one year and now you're making 90 that you're entitled to a modification of support. But if you were making 100 and now you're making 50, that's more likely to meet the standard. However, it's obviously a gray area that in some circumstances maybe 10% is substantial, and that's part of the problem motivating the reforms. Change of employment, it generally means one that leads to a substantial or increase or decrease in income. And also the change of employment and income, these first two factors, need to be considered, and I hate the way they phrase this, but it's got to be considered not temporary, because generally they say changing employment or unemployment is temporary. And at least for currently under the law, if you're unemployed for less than 6 months, it's considered temporary unemployment. And right now, it's next to impossible to get any kind of modification or even relief from your obligation for unemployment before the 6 months expires. And that's only when you're allowed to then begin the process of seeking the modification. So not only do you have to wait 6 months, which are obviously likely to be in substantial arrears of your obligation, but that's when you're first allowed to then file seeking the modification, which could take many, many months more before you even find out if you're going to get any kind of relief. And right now, commonly, if you file for temporary relief, even after the 6 months, you will not get a stay of your payment or obligation, but you'll at best get the right to be heard about it in the future, so your obligation continues to run, which often makes litigating the issue much more difficult for you. So it's almost like a catch-22. They say you're entitled to get a modification because you have a change of circumstances, but they don't change your payment while you have to go through and show the court this. Put you into default and arrears, subject to arrest and loss of driver's license, which makes it next to impossible to have legal fees and have the ability to get into court. Illness, disability after the judgment of divorce was entered, which again would lead to an increase or decrease in income, or likely a decrease in income. And cohabitation by the supported spouse. Now, cohabitation right now is a very difficult issue to establish. They're sort of making it, well, we'll cover this in the reform statute too. They're trying to make what is done by case law, cohabitation is defined by cases, meaning the judges have decided in the past what is relevant. they're now looking to make that part of the written law. And one thing that's not in here, obviously, change of circumstances, is death. Alimony and child support usually does not continue beyond a person's life. Your ability to pay, obviously, when you pass, your estate is not responsible. And if the person that you're paying passes, you're generally not going to be responsible to pay their estate for any alimony obligation, except for arrears. If you are in arrears of your payment obligation, then you may owe the estate, but not an ongoing payment. All right, so how do we modify a provision in the settlement agreement? How does that differ? Because many agreements don't even allow for it. There's sort of a conflict of whether it's permitted or not, because often you'll have an agreement that says we can't modify it. But looking first at the standard, it's the similar, substantial, and permanent change of circumstances not contemplated by the settlement agreement. Now that's important because many things aren't contemplated in a settlement agreement. Anybody who's been through a divorce knows sometimes you're just sitting out in the hallway and you're tired and frustrated and hungry, and you make an agreement. You're not really contemplating anything. And this also may be many years later. You may not remember what was contemplated. And certainly the lawyers who draft the agreement that are later probably going to be witnesses in your case for modification may not remember what was contemplated by the agreement. But generally, you can look at sort of life circumstances and determine what may have been contemplated. If people are working at a basic job with a pension, they were contemplating retirement at a certain age. They're contemplating cost of living adjustments and raises. May have been a history of bonuses, so you would have contemplated receiving those in the future. So you can use a common sense approach, but it's complicated. I usually recommend people take copious notes about what they're considering, and I do while we're negotiating the terms of your settlement agreement, what went into it, so that you know what will lead you to be able to modify it later. And then the Pacifico case, it just says the public policy favors upholding contracts, which basically says if you make an agreement to pay support, and in your agreement you put, which is a very common phrase, that you're agreeing to what's called anti-lepus. Remember I mentioned the lepus case earlier that speaks to modification. If you say there's an anti-lepus clause, it means you're agreeing in advance that it cannot be modified. And that's a bargain for exchange. You're probably paying less because you can't get out of paying it, and the person receiving it might be taking more, or accepting less because they'd rather know that they get it forever. So then a change of circumstances come up, and the question is, if your agreement between the two people said we're not going to change it, then the law necessarily shouldn't allow for it, because otherwise everybody who makes an agreement later changes their mind or finds themselves displeased with it will then come and try to modify it. And that's the purpose behind the Pacifico cases, to stop that sort of floodgate of people deciding that they're just not happy with their agreement. And some people are unhappy the next day, 6 months, let alone 6 years. So it's very challenging to modify a settlement agreement. You may often will have to look to the terms of the agreement. Most will have boilerplate language, and that boilerplate language will say you can't modify it. But even there is case law that says even when an agreement says that, and again, this goes back to the any and all factors thing that you commonly see. Even if you have an agreement that says there's an anti-lepus clause, there's a clause that says you cannot go back and modify it. The court and the case law still say that when there's a substantial change of circumstances, sort of a grossly inequitable result, then even with that agreement, it can be modified, because the court's more concerned with protecting residents of New Jersey than upholding an agreement when there's going to be like a sort of a manifest injustice. All right, so let's talk about the two proposals for alimony reform that are currently pending. The first one is NJA 3909, was introduced March 7th of last year. It's considered by many as an extreme or radical proposal because not only is it eliminating permanent alimony specifically, but it's trying to codify a great deal of the case law and issues. It's trying to build into the statute what judges have done in the cases and decisions. And the main difficulty when trying to do that is judges. No, let me say it differently. Every case is so drastically different that if you try to just put general language into a statute and try to have it apply to every case, it's generally not going to fit. And it will cause problems because judges are required to interpret statutes. So the statute is trying to use a judge's language. It just creates a mess. So let's look at the specifics. Completely abandons permanent alimony, introduces language of imputation of income. Imputation of income is a very common issue when a party is not working or is not working at full capacity. The courts can impute income and say that alimony and child support will be determined based on what they could or should be making, not what they are in fact making. One problem with the way that this reform statute is written is that they introduce the language of imputation of income, but the current status of the case law says you have to be underemployed without just cause, meaning there's no good reason why you're not working at full capacity. The statute just says you can impute income if you're underemployed. Well, many people can be considered underemployed, especially in the current status of the economy. A lot of people are working at less than they could be. And then there's a lot of spouses who have been out of the workforce for a long time, and that's why they can't get a job. But that's having a just cause for the underemployment. This proposal does not allow for that specific language. So it's basically like saying if you're a stay-at-home parent and then you get a job 20 years later at a very low income, that they could impute a higher income because you should in fact be making more. And the reality of life is just that that's not often the case. Sets non-mandatory limits on alimony and the duration of alimony. One thing that's very troubling about some of the things we're trying to codify, I mentioned the 1/3 rule earlier that a lot of practitioners and even judges use to determine income for support. They take 1/3 of your difference. This statute tries to incorporate that when setting the mandatory limits on alimony and the duration. And aside from the fact that a cookie cutter approach doesn't work in every income, fails to address the difference in the income levels and the tax rate. So, one person making $100,000 is taxed a lot higher than a person making 10. So when you're shifting the difference of income, you need to consider more factors than just the difference between the two. It introduces language about suspending and terminating alimony and cohabitation, like I was mentioning now. The standard in this reform is if you can show for 3 months that there's been cohabitation. But now there's many problems with their attempt to codify the cohabitation. Currently, if you're found to be cohabitating, alimony can either be modified or terminated. It's the judge's discretion. Now they're saying it can be suspended or terminated if you can show it, but it can be reinstated if it ends, which in my opinion is ridiculous, because anybody who cohabitates in the first place usually is aware that they're risking their alimony. But if it sort of like gives them the opportunity to take the chance. So if they live together, cohabitate, and cut their expenses, if their alimony is terminated, then they could just say, well, okay, this didn't work, so move out, reinstate my alimony, and do it again. And then what happens if the person begins cohabitating again 6 months later? How often and how many times do you have to, as the paying spouse, have to go back to court on cohabitation? Because cohabitation is very, very challenging to meet in the first place. So if you meet it once, it's almost unconscionable that the person could just say, okay, well then move out since I got caught, and then get their alimony back. Next, it limits rehabilitative alimony to 5 years with exceptions. Again, rehabilitative alimony is intended to help a lower earning spouse get back on their feet, to get additional training, specialized degrees, or even taking lower paying jobs to get experience. I think they went with the 5 years because that could be the average length of time to obtain a degree, a college degree, both in preparation and attendance. But who's to say 5 years and putting 5 years, and then there are many exceptions. So it kind of begs the question of what's the point if there's exceptions. Prohibits modification of reimbursement alimony. As I was saying, that's a very uncommon. I don't know if I've ever seen a case that actually had reimbursement alimony granted. Usually it's just an amount paid or a dollar amount. And Permanent modification, I guess, makes sense because it's based on sort of dollar amounts, but I just think it's an unnecessary point in the statute. Automatic termination of alimony upon full retirement. Now, and this is one of the factors that's really motivated a lot of the reform, is that you agree to or get ordered permanent alimony, and it's not really permanent because aside from the substantial change of circumstances allows for modification. So one substantial change of circumstances has commonly been retirement. So even when you agree to permanent and you seek to modify, then the other side says, well, it was permanent. Permanent should be permanent, and it's not. But now the problem in this reform statute, I guess you can see, as I said at the beginning, I'm not a proponent of the reform statutes at all, or the proposed reform statutes. It speaks of retirement being at retirement age, not actual retirement, which means you could still be working, but seek to modify or terminate your support because you're at the age where you could stop working. Again, it's sort of like the cohabitation issue where they're giving you that option. They're saying, well, you can try it without actually having to give up your job. And if you're successful, you keep working and you make the money. And if you're not, then you could retire and come back again. I just think it's putting too many complicated issues into writing. And then it codifies some case law, but basically that means it's taking some decisions, like I was saying, about the 1/3 rules and the cohabitation language, and trying to actually write it into statutes. Like, for instance, limited duration alimony I mentioned before is for a specific term, and it cannot be modified beyond the term that's set. This proposal is trying to incorporate a calculation, a method to calculate based on the length of the marriage. So, like, if it's 5 years, you get, or up to 5 years, you get 30% of the length of the marriage. Or if it's 10 years, you get up to 50% of the marriage. Or if it's up to 10 years, you get 50%. So they're trying to take away the discretion and make it mathematical. It's conceptually good, but again, you're not going to be able to fit into every case. Every case is going to be drastically different. And I think, as I said before, the criteria that we have in the beginning, if properly utilized, would meet this requirement. The problem is that it's not. So my general belief on this proposal is it's just not a good proposal. I think it creates more problems than it's actually going to solve. All right, let's look at the second proposal for alimony reform, NJA 4525. And also, if anybody's interested in the text for these, I mean, it's pretty easy to get on the internet just by running NJA 4525, or for the other one, one second, searching NJA 3909. But also, if you have any problems finding it, just email me and I can email you a copy of the reforms or give you a link to where you can go for them. So NJA 4525 was introduced November 25th of last year, and it's considered the more moderate proposal, and that's obviously in comparison to the last one. Instead of eliminating permanent alimony, as the first statute did entirely, it replaces the terminology and puts indefinite term. And that's intended to meet the issue I was saying before, where permanent is not necessarily considered permanent because it can be changed. Like I said, with retirement or substantial change of circumstances. The problem I have here is indefinite term, anything. Indefinite doesn't mean anything. If you ordered an indefinite term, for instance, then it can be changed at any time. Now, it may be intended, and I think it is intended, to say that a court can enter for any length of time. So let's say, for instance, in a long-term marriage of 25 years, you would expect permanent alimony. Well, if the parties are in their 40s when they're getting divorced, after, instead of saying it's permanent alimony, you could say it's 25-year term, because that would be the retirement age. And the current statute says it's either permanent, at that stage it's permanent, or it's limited term. So this, in a sense, is one good piece of the reform, that it does allow for a little more flexibility than the current case law allows for. It introduces language to modify or terminate upon good faith retirement. Similar to the first one, it's a prospective or actual retirement. So again, and I said a moment ago that it's problematic because it allows people to get sort of a second bite at the apple. The flip side, I guess, in fairness, is the problem with the current status of law is people won't take retirement or are afraid to take retirement because they don't know if they're going to get a modification. So if you were, and if you're prospectively considering it, a court may reject an application under the current law because you don't have an actual permanent substantial change of circumstances. You have a contemplated one. So you're in a catch-22. You can't do it unless you get the reduction. You can't get the reduction unless you do it. So again, it is a decent proposal. I'm not a fan of the reform, but I think that this proposal is a lot better. It introduces language about modifying support for termination or loss of employment for 90 days. This is good because, like I was saying, that 6-month period of time that I explained earlier that you have to wait to be considered a substantial change in circumstances, it can be very, very devastating. And that's just to allow you to begin the process. So reducing that is a good idea. I just don't know if it's the legislature's obligation to do that, or if we should have, urged the judges to change their opinion on it. So I don't think that's such a bad proposal because I think the current status of the law with the 6 months is very, very problematic. It provides for temporary support adjustments by the court. Like I mentioned before, the problem I've seen routinely in modifications applications is they're granted, but they don't make any change in the support. They allow you to have a hearing to determine if you should get a change in support. The problem with that is it could take you 6 to 12 months to get through a hearing to determine. So your obligation continues with no change in the obligation. It's just not the best way to handle it. So I think the temporary support, allowing for temporary support is significant and important. This similarly introduces language about suspending or terminating for cohabitation. The language of this proposal is similar to the first one that we covered. It's codifying the very difficult standard that the courts already employ for cohabitation. Now here I would prefer a simpler version because the current status of the law on cohabitation requires things like showing a joint enterprise, like joint bank accounts, shared utility expenses, things that don't commonly exist anymore. The world has changed a great deal from the time that these cases that they're using in the statutes came out. People don't generally have joint bank accounts because everybody uses a debit card or a credit card, so there's no reason to create a new account. You have bundled services for utilities, so when you move into somebody's house, their phone, their internet, and their cable's all in one bill. You're not going to add somebody's name to it. There's just no reason for it. So it's often impossible to meet the standard for cohabitation when it's clear that there is cohabitation. So by putting that language in the statute takes away the discretion the courts have to look at it separately, and I think that's very problematic. And then this codifies some of the case law, like I was saying about cohabitation. One thing that's significant about this proposal, and I think if anything is going to be adopted, I think it's going to be this proposal. As a matter of fact, I think that the reason they made the first one so difficult, so radical, as many commenters have said, is so that this one has a greater chance of passing. But this allows for retroactive modification, which is good for many people and very problematic in many ways. It will allow or may allow people that are currently under a permanent obligation of alimony to seek to modify their alimony. Now, as I said before, many, if not the large majority, I think it's over 98% of divorces are settled by an agreement. So you have a lot of people who have made agreements and come to rely on that agreement that now the law changes in a way that they couldn't expect or contemplate, and they may lose what they relied on all of this time. It's very problematic. So it's going to leave a lot to see what happens when it actually comes time for whether or not these reforms pass and what's going to happen afterwards. But as I said, this proposal I think is a lot better than the first one. I think it's addressing some good ambiguities that exist in the law. I still think it falls a little short because I still think that having the laundry list criteria to consider is more important. Now, these proposals, mind you, are not eliminating those factors that a court can consider, at least as far as I've read. So it's going to leave them, but it's codifying this to take away a lot of the other issues. I just don't think it's a good idea at this point. But nonetheless, they are proposed. I don't know what the next status is going to be. I think only time will tell us. All right, so I'm just going to take a moment and shut the screen off and then address the questions that anybody may have. Just give me a few minutes, okay?